to the end of the one, no?
We welcome you all to our annual fest, Kaalchakra's 2026 edition. The theme of this year is labor, tracing histories of work and exploitation. It seeks to critically examine the historical organization of work and labor and the structures of exploitation that have shaped societies across time and space. To start things off, we would like to invite Dr. Melania to inaugurate the fest.
Good afternoon, Prabhu, and all of the members present here. It's a matter of great pride and privilege for me to welcome you all to this edition of Kaalchakra. The name itself signifies that we all agree on one thing, that there are no full stops in history. So when we talk about labor this year and exploitation of labor, there are two incidents which come to my mind. One is in the streets of Southall in London. I came across a mango shop, and being a mango, I always used to buy mangoes, and that's how I got diabetes, right? So I went to a shop, and there I saw green colored mangoes which looked very much like Langra mangoes. And there the sticker said, product of Sudan. So I was wondering, how did the Langra reach Sudan? An immediate thing that came to my mind, somebody from Chhapra or my part of the world must have carried a small sapling when he was being forced into the ship and go there and then burn for there. So, and then again, the other incident that I want to tell you about is that when technology is used to segregate labor so that trade unionism or what they call industrial action becomes a little difficult to control. I have seen many examples of that with the technology coming in. So, this algorithmic management and worker exploitation is something that very soon you will see the world working, because AI is also working in that direction. I recently came across a book which is called Agentic AI in the Workplace. It has just been published. It examines how AI is used for surveillance and to orchestrate marketing campaigns or simulate productivity, raising new concerns about this algorithmic management and digital worker exploitation. So whether it is science, technology, anything that happens, we are back to square one in the chakra, in the cycle, where we see exploitation getting permeated through new agencies in the name of new technology, and the world accepting it as a part of routine. We hear of challenges to the forms of labor with the coming of the new world that we are now seeing, and all kinds of warnings being sent, alarming bells being rung everywhere. Alarming bells. We have a small WhatsApp group in Staff Council where the alarms are being sounded every day on a regular basis by one of our senior colleagues from the physics department. So, all that notwithstanding, I think it is high time that some of us start looking at how exploitation remains a constant theme despite the fact that we think we are progressing. And who could have done it better than Prabhu? He's here, as you all know, he's a scholar on labor, and though not from my period, in my period we are still debating whether slave society existed or not existed in different parts of the world. But here, to have Prabhu for this session, nobody could have been better. I'm so happy that you are here, and the core of my heart, I've known you for some time, and it will be a treat and a delight to listen to you once again. So with that, I declare the Kaalchakra 2026 open.
To start things, for the first event, we we have the honor of welcoming Dr. Prabhu Mohapatra as our keynote speaker. Prabhu Mohapatra retired from the University of Delhi as Professor and Head of the Department of History. His research and publications have centered around ecological and agrarian history, social history of long-distance labor, migration, and history of informal labor and labor law. He received his PhD from Jawaharlal Nehru University in 1990 and held research and teaching appointments at Nehru Memorial Museum and Librar Yale University, University of Amsterdam, Cambridge University, SOAS, London University of Göttingen, and Humboldt University, Berlin. He has been a founding member of the Association of Indian Labour Historians and set up the first fully digitized archives of Indian labour. Amongst his publications are books edited with Marcel van der Linden, Labour Matters, essays in honours of Sabyasachi Bhattacharya, 2009, and ILO and India, Chronicle of a Shared Journey, 1990 to 2019, Geneva 2020. Amongst his research publications are Coolies and Colliers, the agrarian context of labour migration from Chota Nagpur, 1985, Regulated Informality, Legal Construction of Labour Relations in Colonial India, 2005, and From Contract to Status or How Law Shaped Labour Relations in India, 2009. We are very excited to have you here with us today, sir. A very warm welcome. I would now like to invite Dr. Prabhu Mohapatra to kindly deliver the lecture.
I think because there are people here, they would not see me if I don't. It's always nice. Thank you very much. Thank you, Malay. Thank you, all my colleagues in the History Department and students, members of the History Society. I'm really, really honored and privileged to talk to you, young students. The only thing I miss being retired is looking at your bright faces and inquisitive. Also some nodding heads, that helps. But that's what I really miss. And so I'm very happy and privileged. I'm really also happy that you have chosen the theme of labor as your central theme for your Kaalchakra. This is quite amazing, quite amazing. In a kind of just to give an example, we had perhaps one of the largest strike recently against the labor codes on 12th February, in which Kisans also joined in. But not a single mention of that in the newspaper. In the newspaper, at least I read, not a single mention. So this massive attempt to invisibilize labor in that, in a very, very, very strong sense, and I'll show why it is happening. So it becomes very difficult now to kind of hold something to make it even hold, or even to make any demand, or even to make anyone interested in the question of labor. As if labor has vanished. It hasn't. It has never vanished. It existed from the time Malay's time down to ours. So it has existed, it has had many variations. So let me see, I have titled my address today as Contract a Kahani. The title is of course a slightly cheeky nod to the Bollywood film Toilet Ek Brain Katha. I thought it would be a Kahani. I should have added brain in Contract a Brain Kahani. But the comparison is deliberate in some sense. The film was fundamentally about exposing the massive societal hypocrisy, the culture demanding ritual purity while simultaneously forcing everyday indignity upon its people. Today I want to talk about a similar structural hypocrisy. One is this invisibilization, silencing of labor, and so forth. But one hypocrisy which is built into the very foundation of our modern economic life. The legal architecture of the contract. While the legal form of the contract governs everything from mercantile trade to international property rights, my specific focus today rests entirely on the freedom of contract of labor. Over the next 45 minutes or so, we'll trace the deep contradictions, inherent antinomies, and various iterations of the specific legal mechanism across 2 centuries. We are going to explore the dialectic of status and contract, specifically as it applies to the human worker. We will examine how this dialectic played out temporally from 1800 to 2020s and spatially across different conjunctures, comparing the imperial center with the colonized periphery. Ultimately, we'll see how a legal fiction that promised freedom to the laborer was historically weaponized to enforce structural bondage, and how the very divide between the formal and informal workers was legally constructed. So the next section is what I call the philosophy of the promise. And to understand the profound crisis of labor and precarity in the 2020s, we must begin our inquiry in the 19th century, specifically in 1861 with the publication of Sir Henry Maine's magisterial work, Ancient Law. We must place Maine in his exact historical and political conjuncture. He was writing in the midst of a full-scale industrial revolution, the height of industrial revolution, at a time when the fundamental nature of human labor was being radically transformed. Furthermore, he was writing at the absolute height of the abolitionist discourse. The discourse of abolition of slavery had a long history from the 1780s down to the 1860s and 70s. It was a very strong discourse, which is critical of and which led to the abolition of slavery. The British Empire had formally abolished slavery in 1834. Consequently, liberal imperialists and legal theorists were obsessed with defining what free labor looked like in a supposedly post-emancipation world. It is within this crucible that Maine penned what is perhaps the most famous dictum in modern legal history. In his chapter on the early history of contract, Maine wrote the following. This is chapter 9 of his book, Ancient Law. And I want to give you a full quote, so that you understand this inside. The word status may be usefully employed to construct a formula expressing the law of progress thus indicated. Now, what was he indicating? Was a world in which whatever be its value seems to me be the only one which will apply to all progressive societies. If then we employ status agreeably with the uses of the best writers to signify these personal conditions only. Status is what you were saying was a word in a personal world or domestic world, a household world within which all our relations were created. And avoid applying the term to such conditions as are the immediate or remote result of the agreement. We may say, this is the line, this is the punchline, we may say that the movement of progressive societies has hitherto been a movement from status to contract. For generations, this last sentence, single sentence, a movement from status to contract, has encapsulated the triumph of liberal modernity. It painted a seductive picture of a world moving away from the suffocating, ascribed hierarchies of feudalism and caste or religion status towards a world of voluntary, horizontal agreements made by autonomous individuals, contract. But Henry Maine was not merely an armchair philosopher at Oxford. In 1862, just a year after publishing Ancient Law, Maine was very young. Maine traveled to Calcutta to become the law member of the newly constituted Viceroy's Council of India. He became the chief architect and initiator of the great codification of Indian laws which began from the 1860s onwards with the codification of criminal code, then the civil procedure code, the criminal procedure code, laws of contract, and so on and so forth. The whole series which went on from 1860s to 1880s, which we are still maintaining in a way. The Bharatiya Nyaya Samhita notwithstanding, it is the same structure which had been created partly by the initiative of Henry. Bain's theories were not abstract meanings, they became the literal coercive blueprint for colonial legal administration over millions of Indian subjects. Yet, if we read Bain's own historical analysis closely, we realize that the origins of the contract are far from a peaceful meeting of minds. Bain traces the jurisprudential journey of the contract in Roman law through a very specific evolution from nexum to pactum and finally to the mature contract. Let us look at this evolution. The nexum was the most archaic form. It was not a piece of paper signed in a boardroom. It was a highly ritualized physical conveyance. Under the nexum, if a plebeian debtor could not repay a patrician creditor, the legal remedy was manus injectio, the literal laying on of hands. The debtor pledged his own physical body as collateral. If he defaulted, he could be seized, bound in chains, and sold into slavery across the Tiber. And then the 12 tables of Rome actually allowed the creditor to cut the debtor into pieces and to throw it to the thing. It is such a horrific, cruel thing. So Shylock's pound of flesh was not really far from the Roman nexum. The historical origin of the contract, therefore, is rooted in absolute physical bondage of the human world. Now, it's a crucial thing. We are looking at contract as a general thing which affects a lot of relationships, but at its root, it is located in the physical body. Over centuries, Roman law sought to soften this bloody reality through the emergence of the pactum. Pactum. Nexum, from which arises nexus. You know, the word nexus comes from nexus. Pactum. Pact. A pactum was a simple pact or agreement based on mutual consent and good faith. Bona fide. Maybe bona fide certificate, you know, it has something to do with Roman law. Initially, it was a nudum pactum, a naked pact, which lacked the full coercive power of state to enforce it. But as Roman commerce expanded, this evolved into a mature contractus, a fully enforceable abstract legal instrument where violence was supposedly sublimated into civil liability. But where does this evolution land? It lands on the jurisprudential concept of obligation. In Roman law, an obligation is defined as a vinculum juris, a bond of law or a chain of law by which we are tied to perform something. We are obliged to do something. Obligation was actually a legal term. The physical chain of nexum were not destroyed. They were merely sublimated into the invisible juridical chain of the obligation. The contract in its mature form remained a mechanism of binding. To understand the immense psychological and historical violence required to create this binding, we must turn to Friedrich Nietzsche. In 1887, Nietzsche published On the Genealogy of Morals, seeking to puncture the sanitized bourgeois narratives of modern law. Nietzsche asked a terrifying question. How do you breed an animal with the right to make a promise? How to create a promising animal? A promise is essentially a contract extending to the future. To keep it, one must have memory. Nietzsche points out the profound historical link between the German word for debt, which is Schulden, and guilt, which is should. He argues that the oldest and most fundamental relationship between human beings is that of creditor and debtor. How was this memory required to keep an obligation forged? Nietzsche argues it was burned into human consciousness through cruelty, through punishment. To ensure a contract was kept, the debtor placed something they possessed: their body, their wife, their freedom, their life. Exactly as Mahabharata, the famous dice, where ultimately Yudhishthira pledges all his things, including finally his wife, his life here. If they defaulted, the creditor extracted payment through the pleasure, Usasha's pleasure, of inflicting physical pain. The freedom to make a contract, Nietzsche reminds us, was historically forged in blood. The obligation is not merely a legal abstraction, it is an internalization of the threat of violence. Finally, we must turn to sociologist and historian Orlando Patterson to completely dismantle the intuitive equation that status equals bondage and contract equals freedom. In his seminal work, Slavery and Social Death, Patterson shatters this dichotomy. Patterson rejects the simplistic definition of slavery as merely property in human beings. Instead, he defines slavery as the permanent, violent domination of natally alienated and generally dishonored persons, a state of social death. But his most radical insight is his assertion that the Western ideal of freedom was intimately bound up with and parasitic upon, as a parasite, it fed upon the institution of slavery. It was the presence of the socially dead slave that allowed free citizens to conceptualize their own liberty. Freedom was not the opposite of slavery, it was birthed by it. Furthermore, Patterson demonstrates that master's absolute domination over the slave becomes the historical and legal template for the modern concept of dominion. The domain, the whole idea of domain, which is linked to property rights, right over dominion, absolute property rights. So, while everyone said, therefore, modern freedom of contract did not abolish the logic of slavery. Rather, modern property rights are deeply infected by the historical template of absolute dominance. That means slavery is not created by property. That means slave is not one on whom we have property. But actually the idea of property could come, an absolute property right, that I can do anything with my property, comes from the idea of slave. That is his belief. The free individual's absolute right to contract out their labor was modeled on masters. When we combine Maine's Nixon, Nietzsche's pain of the promise, and Patterson's social death, the liberal myth of contract collapses. To fully grasp why this myth collapses, we must ask a fundamental question. What precisely is a contract? In classical jurisprudence, a contract is defined as a legally binding agreement between two autonomous, ostensibly equal parties for the exchange of some value. You can't just have an agreement, you must have an agreement, but also it must have some exchange. Historically, its primary and most successful application has been in commercial transactions, the buying and selling of goods, property, or mercantile services, or financial transactions, debtor, credit. In the commercial realm, the contract functions relatively smoothly because the commodity exchange is alienable. It can be entirely separated from the seller. You can separate a sack of grain from the merchant who sells it. But what happens when the commodity being contracted is human labor? It is precisely here on the question of labor. Now remember, how the whole idea of contract was based on the body, but right now I'm coming back from the other side and saying the question of labor which makes it difficult for the contract to operate. Why? That the grand liberal fiction of the mutuality and freedom of contract completely undergoes. You cannot separate labor power from the physical body. The time, the sweat, and the personhood of laborers. When applied to labor, the contract is forced to mask a profound structural asymmetry. The formal freedom to contract out one's labor is invariably structured by the sheer compulsion of economic survival. The labor contract, therefore, never just a neutral commercial transaction between equals. It is a mechanism. Not yet. It's a mechanism of subordination dressed up in the judicial language of mutual agreement. It is with this theoretical structure or understanding, if you can get, the understanding of the contract not as an emancipation from status, but a sophisticated technology of obligation, that we must now look at what happened when the British Empire brought this mature law to the shores of India. The illusion, the first site at which I'm going to look at it, the first one, is abolition and the translation of bondage. Before a journey to the colonial periphery, we must confront a massive ideological contradiction at the heart of 19th century British Empire. The abolition of slavery in the Caribbean was fundamentally different, the Britishers thought, from slavery in India. In the Caribbean, chattel slavery was an artificial system created for mass extraction. In India, British administration encountered forms of agnostic servitude that were deeply socially embedded in the hierarchies of caste and religion. Terrified of inciting agrarian unrest, there was a profound delay in delegitimizing slavery in India. 1834, British Empire, they abolished slavery. But in India, they had to wait for another 10 years at first delegitimizing slavery, not abolishing slavery. Only in 1860 in the criminal code that they first fully made it criminal to hold a slave. But what they did in slavery was to abolish the legal character of slavery. Okay? Delegitimize the slave. When the colonial state finally abolished the legal recognition of slavery, capital still needed immobile, cheap labor. How do you maintain a captive workforce? The answer was the contract. As historian Gyan Prakash demonstrates in Bonded Histories, the colonial state confronted traditional caste-based agrarian dependencies like the Kamiyas of South Bihar and completely recast them through the lens of colonial legal discourse. The low-caste laborer was legally reimagined as a free individual who had simply taken a cash advance and was now contractually bound to work of the debt, and which he could never work. So it allows for you to reimagine. He is not a slave, he is a free person who has contracted a debt and then debt he cannot pay. The archaic status of the slave was now not abolished. It was merely dressed up in the modern juridical clothing of the contract. The nexum had returned, disguised as the pactum. So then I look at another side, and that's important. The legal sleight of hand was actively constructed by colonial state at the very heart of its urban centers. As historian Nitin Sinha has demonstrated, domestic servants in early colonial Calcutta were among the very first groups subjected to formal master-servant relations, transforming everyday conflicts into juristic offenses. This regime of criminalized free labor expanded rapidly into manufacturing. As Ravi Ahuja has shown for early colonial Madras, the colonial state constructed a formidable legal archive to bind labor. In my own work, Calcutta bylaws was enacted from the early 19th century at the behest of European manufacturers. Artisans taking customary advances and abandoning work were punished with imprisonment. The advance, historically an index of workers' freedom to bargain, was transformed into a mechanism of absolute control. This regime was codified into universal law with the Workmen's Breach of Contract Act, the Act 13 of 1859. The Act declared that taking an advance and failing to perform the work was fraudulent, punishable by rigorous imprisonment. Act 13 became the informal sector act par excellence. It was used widely, uh, uh, widely in many situations, mainly where Europeans were confronting Indian labor, but also by Indian employers of small workshops and so on and so forth. But this logic reached its terrifying zenith when British capital required a massive workforce to clear the malarial jungles of Assam for the global tea trade. Faced with a labor shortage, the colonial state invented a new system of bonded labor, passing exceptional plantation laws, Act 6 of 1865 and Act 1 of 1880. The breach of tea garden indenture was a criminal offence. More terrifyingly, the state granted planters the extraordinary private power of arrest. A tea planter could hunt down a fleeing worker without warrant and physically drag them back. We must listen to the workers themselves. In their work songs, they call the plantation system Bhata, literally the jail. This was the ultimate expression of what I had called regulated informality. During the height of the 1882 Act, mortality was apocalyptic. 1 in every 4 adult workers did not survive the full period of contract. Yet the state continuously justified this violence. As a civil surgeon bluntly summarized, it was ultimately a question of tea and money versus human life. But of course, history, as we know, and as Malay pointed out, tends to, Kaalchakra ghumta hai. What we would call in other ways, history is, however, deeply dialectical. In the 1920s, the brutal architecture of master and servant laws faced an existential crisis. In the post-World War I conjuncture, shaped by the ILO and massive domestic upheavals like the Great Bombay Textile Strike of 1920 and a series of strikes immediately after the First World War, and most importantly, the Bolshevik Revolution, the state's hand was forced. To diffuse growing labor militancy, a new regime of pacification emerged to explicitly juridified the employer-employee relationship. At its heart was the legal invention of what we now know as the standard employment contract. As legal scholars Simon Deakin and Frank Wilkinson point out, this was essentially a reversal, or looked like a reversal of Henry Main's dictum, a movement from contract back to legal status. Because it is under a legally defined who is a worker that you get a legal status as a worker. This new legal instrument created an open-ended contract built upon mutual obligation. This is what the state intervened to ensure a braiding together of welfare and the obligation to work. In exchange for subordinating themselves to the management, the worker gained the protective status of an employer. Now remember, this is not something which is happening only in India. This is a worldwide trend which happens from the late 19th century, when the big, the master-servant laws, which are the only law, workers were called servants and employers were called masters, till 1875 in Britain itself. So the word employer and employee comes into play only from 1875 when it was abolished. Now, what were the 3 major global forces which was leading to this abolition of, or the shift in the character of the of this penal contract, of the master-servant regime of labor? First was a major change in the system of production, methods of production. Now you have new emerging, huge, in the late 19th century, beginning in Germany first, huge emergence of large firms called vertically integrated firms. Okay, that means a firm which not only just produces one product, it produces all, the whole supply chain is under its. For instance, by the 1920s, Ford owned rubber plantations to produce tires for its plant. So you from steel factory to rubber plantation, they owned the whole chain which made up this. So this rise of this thing is from the late 1880s. That's one. the rise of joint stock companies also come in here, which no longer is only individual owners but a shareholder based. That is one. Second is the labor movement itself. That was very important that throughout the 19th century, at least in Britain, despite legal protest being criminalized, workers protested a lot. It was the Conservative Party, the Tories, who under Disraeli in 1867 and then in 1875 finally abolished it. Okay, that's the second thing. The third simultaneous rise is of what we today know as social policy. It was actually strangely from the aristocracy and from Bismarck, the Chancellor of in order to fight social democracy, the Marxist social democracy that was rising rapidly in Germany, started a policy of what is known as social insurance. The origin of unemployment insurance, social policy of health and so on and so forth were given to workers if they don't have. So it was a form in which workers were depoliticized but were given social welfare, something that you can see now happening in many ways. Nevertheless, in India, the foundations were laid, as I said, first time in 1923, after the 19. This is the time in 1920 ILO also comes about. India becomes a founding member of ILO, and this leads to the first law which actually uses the term employer and employee. It is in the Workmen's Compensation Act of 1923. Though a very limited act, the overturning of the penal contract regime can be seen. And a new nexus is created between employer and employee. Before that, employers were not liable to compensate according to the English common law, not liable to compensate. It is only from the Workmen's Compensation Act in India in 1923 and in England in 1906 that first time the employer is made liable for an act of injury of the worker. They might have given charity or ex gratia compensation, but actual liability was not there. Because under common law, there were two rules. You know, common law had this based on judge-made law and it was case-based, not like court-based like Indian law is or civil law in the continent is. So what was it important? It was called the fellow servants rule, by which it was said that since you knew when you joined work that you might get injured by your action of your fellow servant, you will not. So you already knew and you entered the contract with fully knowing this. The second was called the contributory negligence. There also you knew that your own act might lead to injury, or you might, through your negligence, contribute to your own injury. So for these two reasons, you will not be given compensation. And only over the long fight by the trade union movement and the labor movement that alongside the overturning of the master-servant regime, we also have the beginning of what is known as the employee-employer relationship. And this nexus in India is first in 1923, then the penal contract regime is overturned through legal overturn in 1925. First time trade unions are given legal immunity in 1926. Before that, if you did trade union work, you could be imprisoned because you are trespassing. You are trespassing a private property, so you would be imprisoned. So it was only an immunity given to trade unions under certain restrictions in 1926. And then the fourth thing was a major thing, Trade Disputes Act of 1929, which came out immediately after the longest strike in the history of workers in the world, a 6-month-long strike in Bombay Textile in 1928 led by the communists. Young Communist Party youngsters, Daghe, Nimbarkar, various young people, they are hardly 22, 23. They led a massive successful strike and they won that strike. Of course, immediately after they were all put to jail under the It's like a lot of our students are in jail. They were leading strikes, like these guys were leading strike. They all put in under the mirrored conspiracy case and languished in jail for several years. That killed the strike. It is to pacify this type of labor, a new labor law was created, Trade Disputes Act, which it did. It was a first attempt to bring together the possibility of state entering directly into industrial disputes. First, state was intervening earlier also, but now it will intervene there in order to diffuse that risk through various modalities. Most importantly, by declaring certain as public utilities where you cannot have a strike, or you have other forms of arbitration and conciliation. Now, it was while this bill was being passed in 1929 that Bhagat Singh, through his bomb, which was actually not a fatal bomb, it was to bomb to wake up the people, as you know. It was actually as exactly as not in the Public Safety Act, which was also discussed, but he did it during the time when the trade unionists, the trade union members, few of them were in the Imperial Council, like Ellen Joshi, were vehemently arguing against this state law, the new interventions. And well, Bhagat Singh was, of course, then that he died. But it is very symbolic and in some ways very prescient on his part that he used this to protest against this law in this manner. This led to, these foundations were laid there, and its absolute cornerstone. Then in the 40s and 50s, a series of laws were passed, which Paternity Benefits Act, Payment of Wages Act, Child Labour Pledging Act, several of such acts were passed, ultimately in 1947. And here, the role of B.R. Ambedkar is very important. Ambedkar was a labour member of the Viceroy's Council during the war, and he crafted what we know as the modern employment contract regime for India. Drawing from past, also creating new elements, bringing in new elements, braiding together a particular way in which you have juridified or tried to create a particular conditions, and this came out in the Industrial Disputes Act of 1947. The IDA institutionalized the employment contract by legally defining the workman as a direct employee, strategically excluding government servants, domestic workers, and crucially contract workers employed through middlemen. For public utilities, the Act mandated compulsory adjudication and 14 days strike notice. If you give notice for 15, 16 days, you will be yourself being thrown out of the thing. So there is very little chance of doing legal strikes, effectively criminalizing a vast swath of labor protest. Trade unions, at times All India Trade Union Congress, the oldest trade union, fiercely opposed this as an apparatus of excessive state intervention. Nevertheless, this architecture institutionalized the sharp distinction between the formal and informal sector. If you are within the formal employment contract, you possess the protective status of an industrial citizen. The dirigist regime remained the normal in India till the 1980s. Created beginning from the 1920s down to the 1980s, over time was created this what we know as the standard employment. In India, it remained confined to never more than 10% of the total workforce. And a lot of the workers were kept out of it through various means, through thresholds which are implicit in the law itself from the 1920s. Now I'm quickly going on to look at what happened in the 80s and 90s. So that throughout these 20s and 80s we had, as we moved into the 90s, a massive structural rupture of globalization ushered in a neoliberal paradigm. Beginning from the 80s, actually one should begin from the 1975, the emergency. Emergency created the last, it's very paradoxical. It created the basis on which later, by suppressing workers' protest, it created the basis by which later you had the coming of the globalization. As we moved into the 1990s, a massive structural rupture occurred. Globalization ushered in a neoliberal paradigm. Capital demanded flexibility, launching a direct assault on collective rights. Now remember, the employment contract was not an individual contract. It was a collective contract. It actually, a series of laws which were created in the 1940s, including the Employment Standing Order, and the Industrial Disputes Act, and the Minimum Wages Act, which came up in 1948, and Employer State Insurance Act, all these created a collective personality of labor. It was the collective of labor and the employers who supposedly should have bargained. But that often didn't happen in practice because there was no enabling legislation saying you must bargain. On the other hand, it said you must conciliate. You will be forced to, or you will be sent to a tribunal where you will be adjudicated, which is quite different from actual bargaining, collective bargaining. But anyway, the legal personality was the collective one. Now this shifts in the 1980s and 90s, some of it already in the 1970s, by which the collective labor is transformed into individual contract. That the capital demanded flexibility, launching a direct assault on collective rights, arguing that true freedom lay in the individual contract. Now, in the 70s, in fact, I just wanted to. So, if you look at the whole arc that I'm saying, let's say you had earlier the master-servant law, the penal contract, where worker is not there, he's a servant. Now, that shifts slowly when you become an employee. And then, in the 1980s, you are employees again. So, in the period of the 1970s and 80s, there was a great, or 60s especially, there was a great pessimism, especially amongst the freedom of contract theorists. The most famous among them was a writer called P.S. Athiya, who wrote in 1979 wrote a book called Rise and Fall of the Freedom of Contract, showing, and many others argued that actually we have, I think contract regime, contractual freedom has gone because now you have been replaced by the employee status. So now we have reversed historically. They were reversing, they're seeing it as reversal because of the decline of the what you call the individual contract. But again, when the new contractual regime starts coming back in the late 70s, 80s and 90s in India, new books start coming out. Rise, fall, and the rise, further rise of the contract, freedom. Several books came, several articles came, looking at this as a new form of new individual contract regime which has come. To grasp this defeat, I want to, okay, the protective architecture was systematically dismantled through outsourcing and flexibilization. Massive vertically integrated cotton textile mills in Bombay and Kanpur were shut down, and production was outsourced to the unorganized arms. 80s se shuru ho ke, all the big centers, Kanpur, Ahmedabad, Bombay, and Calcutta for June, all of these go into a massive crisis. And this is happening during a period when the labor law itself has not changed. The architecture, formal architecture has remained the same, but the state has allowed the hollowing out of the content of this, the so-called employment contract. You know, the collective labor was being transformed and being dismantled. What you call the employment contract was being dismantled not through law. No change in law happened. In fact, paradoxically, the laws became supposedly more rigid during the emergency and after that, in 1976 and 80s. Strangely, but all the what you call de-industrialization of India happens in the 80s and 90s. When huge lakhs of workers, Bombay had 250,000 workers, 5 lakh workers in the middle of the city. And they all were thrown out of jobs. And it took a long time, but now you know in these mill areas have become massive housing, residential products. And it's quite a sad thing. The mills have been transformed into malls, and the financialization of Bombay from an industrial city to a finance city has happened, with a lot of consequences for this. capital could now utilize a highly flexible, entirely unprotected work. And this happens alongside a massively declining power of the organization. Now this, to grasp this defect, look at the data on industrial disputes leading up to the mid-2008. Look at from 1960s down to this. What you have in the red is the number of strikes. You see the peak in 1974, that is the railway strike, when the maximum number of days were lost. And after that a big down, and then 76 and all, and then slow decline of it. So much so that the lockouts, that means the strike by capital, not strike by labor, but strike by capital, by which you lock out, you don't allow the workers to come in. Now the mandates lost to workers increased massively. That means that they were allowed to lock out without fear, despite no formal change in law, which only happens in the 2020s. Now we have come to the last section, the platform economy and the death knell of the labor codes. Following the 2008 financial crisis, the global capital initiated a frantic drive towards digitalization. This birthed the platform economy, and the most defining figure of the 2020s, the gig worker. The Uberization of labor relations is the ultimate expression of a neoliberal dream happening during a neoliberal crisis. It's a strange thing. You dream, usually it's a nightmare, but you dream during a crisis. Platform capitalism utilizes technology to achieve the 19th century planter dreamt of, absolute control without liability. The gig worker is the juridical reincarnation of the independent contractor. Now that is important. The emergence of the employment contract meant a sharp distinction between what is called an independent contractor, that means consultant, or an independent weaver, and an employee. So it was very distinct division which allowed for the employment contract emerges by clarifying the laboring landscape between several other forms of labor and privileges the direct relationship of employer and employee. Now that's a dream, it never completely vanishes, but this theoretically is now returning. Now they are no longer called workers, they are called associates, executives, or whatever the name, partners, and so on and so forth. Platform capitalism utilizes technology to achieve what the 19th century planter dreamt of, absolute control without liability. The gig worker is the juridical reincarnation of the independent contractor, entirely stripped of protective status. The algorithmic act acts as the modern Dagni. Dagni is the system of advances which is to be there in the 19th century, late 18th century, 17th, 18th century, and even in 19th century, dictating the piece rate and disciplining the worker. The worker takes on debt to purchase the asset, forced into endless self-exploitation. It is the technologically mediated return of the next sum. Tragically, the Indian state has accelerated this dismantling. The death knell of the formal employment contract was sounded with the 4 labor codes. Under the guise of ease of doing business, these codes execute a severe dilution of workplace safety, pave the way for 12-hour shifts, and dismantle factory inspection through self-certification. By extending public utility restriction to all establishment, the right to strike has been legislatively asphyxiated. As we stand in the 2020s, facing the threat of labor redundancy, now it's no longer a question of labor being thrown out of jobs. There's no jobs. Driven by artificial intelligence, the kahani of the contract comes full circle. Sir Henry May promised us a movement from status to contract. But our historical journey from the Bengal weavers forced to take the Dagni, to the indentured police trapped in the Assam Fatak, to the precarious gig worker bound by the algorithm reveals a darker truth. In the absence of state protection and collective bargaining, the freedom contract is merely a judicial veil. We are witnessing a great historical regression. The contract has once again become an instrument of extraction and structural bondage. If we are to survive the coming crisis, we must look to the lessons of the 20s and demand a new legal and political architecture, a new reorganization of labor that brings welfare, dignity, economic security back into the right, to the very definition of labor. I want to just end with a favorite poem of mine from written by Philip Levin, the great working man's poet of called Cipriano in the Wind, 1979. Where did your words go, Cipriano, spoken to me 38 years ago, in the back of peerless cleaners, laundry? Where raised on a little wooden platform, you bowed to the hissing press, and under the glaring bulb, the scars across your shoulders, a gift of my country, he said. Deep like old wood. Dignidad, you said into my voice, wide-wise, without is no riches. Dignity, without dignity, there's no riches. And Ferrante, the dapper Sicilian bootmaker, laughed. What could your pants pressure know of dignity? That was the winter of 41. It would take my brother off to war where you had come from. It would bring great snowfalls, graying in the streets, and the news of death racing through the halls of my school. I was growing. Soon I would be your height, and you would tell me eye to eye, someday the world is ours, someday you will see. And your eyes burned in your fine white face until I thought you would burn. That was the winter of 41. Batan would fall to the Japanese and Sam Baborsia would make the long march with bayonet wounds in both legs. And somehow, in spite of burning acid splashed across his chest, and the acids of his own anger rising towards his heart, he would return to us and eat the stale bread of victory. Cipriano, do you remember what followed the worst snow? It rained all night, and in the dawn the streets gleamed, and within a week wild flocks leaped in the open fields. I told you I have a word for it, spring. And you said, spring, spring, it always comes after. Soon the Germans rolled east into Russia and my cousin died. I walked alone in the warm spring winds of evening and said, dignity. I said your words, Cipriano, into the winds. I said, someday this will all be ours. Come back, Cipriano Mera. Step out of the wind and dressed in the robe of your pain. And dressed in the robe of your pain, tell me again that this world will be ours. Enter my dreams or my life, Cipriano. Come back out of the world. Thank you.
We'll be taking some questions from the audience.
My God, why is it so bloody warm? Huh? What happened?
Thank you, Prabhu, for this very enlightening lecture. And I mean, I've known you for, I think, more than 30 years now. So, and being always enthralled by your lectures. Now, this reminds me. Yeah, more than 30 years.
Oh, Ajay, when you were a little baby.
Yeah.
Yes, I got it.
No. Yeah. So, I mean, and, you know, coincidences, I mean, 20 years back in Kaalchakra in 2006, you were the keynote speaker, and I still remember, it was our first year in college, and you spoke on the indentured labor in Benjamin at that point of time. I now throw this floor open to questions. I have a couple of questions from myself, but I'll keep them to the end. So, would you like to take the questions one by one, or combine 3-4 questions together and then?
Yeah. I think there are 3. One. So that I can.
I can miss some questions. Don't destroy a good question with a bad answer.
Sure. Sure. Yeah, so anyone?
So you very rightly pointed out that
Please introduce yourself.
my name is Yashasri. You very rightly pointed out that servitude is deeply embedded in caste and religion, especially in the South Asian context, because the workforce is deeply hierarchized, both in terms of caste, class, as well as religion. And again, the organization of the workforce, at least in the pre-colonial period, is based on castes and subcastes and the guilds that they're able to form. Again, these guilds might be in constant interaction and negotiations with maybe local merchants or be it the imperial household. So, for instance, we have the Mughal Kaalchakra. But when we were talking about the 19th century imperial laws of subjugation and other legislations on the welfare and work, how are these caste loyalties and alliances they are being broken down, and are these caste groups exhibiting any signs of resistance per se?
Anybody else?
Sir, my name is Akash. I was thinking about somewhat the moment that you were talking about in terms of what Queen has to say about things in terms of contractual labor and how we think about maybe the idea of the opium trade where we find maybe in kind of a fictional work yet very significant like that of Sea of Poppies, that how the militarized labor at one point of time, right? And how the wounded idea that the guy gets wounded and then of course is re-employed into the entire idea of the contract where this person has been made to kind of produce and provide opium to the factories, right? How kind of that process that it moves from one sphere to another, from the militarized into the contractual labor of the other kind, right? How would that kind of a moment unravels in this entire dialogue?
Most of it is actually, I think Najab should answer it, but he's not here yet. But it is quite crucial for my own understanding, and thank you very much for this too. You want? Okay. You want to answer me?
No.
Dare not to. In the contract.
First and foremost, we are not sure that actually the 19th century or 18th century or 17th century had this kind of organized caste-like guild or guild-like caste associations. Maybe we know a lot about merchants, but workers' caste, they're like the guild system in whether it is in Turkey or in Europe, in many places. It did exist in India in that form, but that didn't mean that there was no caste groups and associations. You would know that Thankar Roy was a very important economic historian and a very good friend of mine, but he's tried to organize and say that it is these indigenous groups who are now led by these sardars and mukaddams, who are the caste leaders, who now come into being. It's not clear from the evidence we find, even the evidence which the Thankar gives, whether they are carryovers from the past or are they reconstituted in the early 19th century. So it's very difficult. Historians always have this problem of trying to find when the shift and change is happening, whether it's just a carryover of the past or a new form is emerging. For instance, a lot of these new form terms which came have an old links. For instance, your Pinju here is working on the Laskars and things. The Laskars were seamen. Actually, they were originally from the military labor market, and then they moved to being called seamen. Okay, so if you think that the military laborer has moved to sea, no. It's a kind of shift in the name. Sometimes the name For instance, the word serang, okay, it is actually something which arises in the Portuguese, like mistri. The word is Portuguese, and it has now transformed itself, maestri, master, which is again coming from a guild structure with a master and journeyman structure. Now these are transformed into many workplaces and areas. Okay, even now we call mistri all the auto mechanics or many of them call mistris. I even heard the word serang not only in this area but where I was born in an industrial township. The serangs were the overseers of the industrial workers group. Word jobber. Jobber is typically a new word which comes from, not from any traditional thing, but jobber is someone who actually existed in English factories. Similar structures existed throughout. Now they are the ones who lead a group of workers and take on piece jobs within the factory. Sometimes they might go out of the factory and work. Now this jobber is transformed in Indian context into recruitment leader and a leader of, or say, head of actual manager, that means he, and sometimes also as someone who is controlling the neighborhood spaces, you know. The brilliant book article by Rajna and Chandavarkar, we know how these jobbers created in the neighborhood their structures of power by advancing money, by providing food and so on and so forth. They were both recruiters and line overseers. Then also Sardar, the word Sardar also. All these have so the question is, how much of these terms are pre-colonial or have been reconstructed? Now this is a very important thing. I gave you an example of the emergence of what is called the master-servant architecture in India. It was not utilized everywhere, but it existed in the law books and it created a kind of a legal aura around which so many of the big mills didn't work on the industrial mills didn't work with the some of them did, but not all of them. What was used was a hybrid of this intermediary indirect control plus this direct master-servant law of criminal breach of contract. It is this hybrid mixing which marked the Indian labor landscape on the 19th century. Raj Chandavarkar has again shown how this jobber starts being initially seen as a great help to the colonial masters, who are very happy that they don't have to do it. If you read Dipesh Chakravarti's very good book, Rethinking Working Class History, there also he says the Sardars, how the actual managers never directly controlled workers, it was the Sardars who did. Alright? So this indirect delegation was a very important way. But slowly, as it shows how the Sardar or the jobber started becoming an impediment to direct control. And then the decline of jobbers starts in the 1930s, 40s, and the rise of the new feature called the labor officer, labor welfare officer. My father was one, so I know it very well. It was actually a 40s creation, a new, which tries to be, to replace the jobber. Jobber now was, first the jobber is seen as an impediment by the colonial state and then by the labor movement itself. So this anti-jobber feeling, which was initially pro-jobber by the state, moves towards the 1930s and 40s and shifts. So the jobber system declines. It takes a long time to decline, but it declines by 50s, 60s. So the key question remains, what you say. The second question which you said, it's very true. And this I should have flagged, but I can't say a lot. I could have taken I had a lot of things to say, but it's very difficult to chew. I thought I had chewed a lot looking at 200 years, but it could have been important for me to have put out that actually it is the military labor market of the 18th century. And in the military labor market, you had developed a lot of systems which we later find in the employment contract. Pensions, If you are wounded, you are given compensation, and so on and so forth. Many of these, the Lal Kurta army had lot of this. Baksariyas and all, where all had this thing in the 19th century, 18th century. In the 19th century, this is shifting and changing slowly as a more rationalized military formation emerges. But military still continued, military labor market still continued even under formal standing army structures which emerged later, Indian army, many of the elements of the old thing, like for instance pension. Well, the notion of pension was not there for anyone else. Maybe policemen and them, they had this pension thing which was there. So some of these benefits were there. But of course, there were several shifts which took place in the military. So military labor market could have, or military labor could have been seen as an early model of something like what happened in the 1920s in India. Could have been. But in between there were so many shifts and changes that it no longer remained the model for. Instead, what we have is the master-servant model, which now becomes a template for organizing labor, deploying labor, disciplining labor for the 19th century and early 20th century. Not just that, the shift, the so-called, what you call the employment contract, standard employment contract, is itself, you can see, seeping in or seeping into of the master-servant law. Master-servant law dies, but it slowly, it goes inside it. For a long time, one of the tests by the in the courts, was saying, is he a worker or is he just a contractor, contract labor, indirect employee? Is through the test called master-servant test. Even now, who can I directly direct him to work? It's still called the master-servant test. So in many ways, the employment contract did not totally negate it, but just like, the Hegelian dialectic, the thing, the antithesis doesn't totally abolish it. It actually sublimates it, off-bound, which Hegel would call. It sublimates it and makes it, it dies, but it lives on in a kind of form, either in the form or as a content. The same we could see if you look at these names for laborers, the very laboring groups and caste groups and heads and all. The terms used have a very interesting history. If we can locate the shift the terms have gone through, we get an interesting history. But we should be careful distinguishing between form, the name, the nominal aspect, and the essence, the content. The content might remain the same while the name changes. The name might change, but the content remains same. The historian's job is to see this particular dialectic between the content of a concept or a content of an artifact, historical product, and see whether the content has transformed or the form has transformed. Form has transformed, content same. Content has transformed, form is the same. This is the university allows us to look at these questions which have, I think, value for everyone, including Malaya's period and all. I think looking at these broader questions of, for instance, the discussion between status and contract can be seen once. It's not that Roman law में contract हो गया उसके बाद कोई change नहीं हुआ. It changed, it shifted, changed. That was in the 3rd century BC. The final contract form is emerging there, property form. But it had many different history. Maine was a great admirer of Roman law. While in England, it was basically Roman law was somewhere else, but he brought in Roman law into an idea of codification and so on and so forth. Okay.
Yes.
Second question. Am I audible, sir?
Yeah.
Thank you so much, sir, for that insight. I'm Jasmine from the Department of Sociology in House. And my question is, from the pathway you mentioned, look where gig economy workers have to buy these equipments. Oftentimes they have to load sometimes, and then they have such meaningful risks. But then you see the interviews of the gig economy company owners, and their perspective is that we give freedom of work. We have flexible work hours. You can come and work anytime that you want. It's just another excuse to not give them employee benefits, and that's the reason they do not give them employee benefits. So how do you ensure? So this is very sociological question, very humanist question. That how do we proceed? How do we proceed to give them a proper recognition or some kind of benefits? Like how do we mediate between these two extremes? Because we also have even the economy from a capitalist point of view, even they have a point, and then there's basic respect or dignity of labor that we call it. So how do you see this?
You want to ask? Yeah.
My name is Arish. I'm from study history here at St. James College. My question is that, as discussed, the usual liberal defense for the coercive contract is consent, that the worker consented to the contract. So, in this sense, do we then should we now leave the categories of free and unfree labor because even back then and now the contract is a result of economic coercion. So then should we look at labor in terms of only degrees of power, or do the categories of free and unfree labor still make sense?
Okay. That's a very good question. Interesting, but I think my paper was a way to kind of look at this question. And by presenting it, maybe I have put it out too much towards the little nuance has been lost in my. So maybe there are some issues which I'll answer just now. But I'm taking up your question. Now the gig worker or this new form of worker now, if you know anything about the labor code, you know that there is a social security code which has integrated a lot of this, maternity benefit, all these other, many other laws have been put together. Interestingly, in the social, the social security, there is a kind of provision of social security of gig workers without recognizing them as workers. It's very interesting how this labor code doesn't recognize them as workers, but provides them some amount of kind of insurance and things like that, social security. Now this is one of the ways in which the state has, what it has done is, it is now saying that the gig workers, if you force the state, the employers to provide social security like any other day, it would make the gig work less competitive and the employment potential would be harmed. But it has been always like both the domestic worker. Now you know that later, when if you're reading anything, Supreme Court, while dismissed this or not yet dismissed, but they made such a rotten comment on the fact when the domestic workers are demanding their status as workers, they said, how can they be workers? It will create a havoc in our families. There will be so much litigation. The moment you are a worker, according to the judge, you are always in conflict. He was right. He was right because it is a conflicted relationship. But he wants to hide it, and that's what is hide it within the domestic world, exactly as it was there in this pre-contractual world, where the power of the father over wives, children, and slaves, called patrias potesta. This was the power which they hold. Down till the late 18th century, the servant was seen as part of the household. He didn't have a legal kind of personality. In fact, they were not even, the master-servant law, after some time, did not apply to them. And in India, when Lord Macaulay came, he did not want to give the domestic servant, though in the 18th century and early 19th century, a lot of domestic servants were regulated through master-servant laws, by criminalizing them. But in the actual law which came out in the Criminal Procedure Code, he only fixed on two things. He said, no, normal relationship between servant and master should not be put under law, just like domestic households. You know? Like a relation between husband and wife, you cannot put it under law in the sense the wife does not have she cannot be a witness that time against her husband. You know? She is part of and there is a whole legal theory of community of property and so on and so forth. There are many other things about that. But it is to domesticate, that's to bring it into the domestic fold that some of these things were made about, all these laws which gig workers and all, they are not, so on the one hand, domestic workers are not workers, so they won't get minimum wages, they don't have the protection of any benefits or anything because it will destroy them. That's one. Then the gig workers are like independent contractors. Exactly the thing which had been carved out in order to create this special relationship between direct employer and employee under the employment contract. Now this whole thing has been brought back in the gig economy. So he's a consultant, like a consultant cannot have, he cannot go and fight for. So Uber drivers cannot. It's a big. It's not only a problem in India. It's throughout. In California they allowed the Uber driver employee status. Then through a domestic referendum under the last election, they reversed that law. In London, they have allowed Uber drivers to be seen as employees. But again, it's a very, very high status. So the only answer, like Goa taxi driver, they don't allow Uber at all to come in. In many other places, they just don't allow Uber to come in because they are really like scabs. They are not cabs, but they are scabs. You know what scabs are? Those who break strikes. So in a way, there is a kind of tension which is there in many places about this and so on and so forth. But what you said, Akash, Arish, what's that? What is it? Brave soldier? Why is the brave soldier hiding behind this word? You should say Bahadur or something. So Arish, wonderful question. So now this question is very difficult, but in a way difficult to answer. I think I just showed a little bit of the thing. Capital Volume 1, Marx. I didn't mention it because it's unmentionable. I don't know what it is. So I didn't mention it. But Marx very clearly located the double quality of this so-called free labor. So in fact the word he used in German was Vogelfrei. That means free like a bird. Free like a bird means you are free, you can freely go, choose your employer and all. But you can also target for capture. You can be targeted and you are free like a bird but also free to be shot down. Okay. Now this remains a central point of conflict. Now one of the ways Marx tried to say is that the formal equality is crucial for the formal freedom is crucial for the operation of the labor market and for the law of value to operate. It should be based on a worker owning something and employer owning something and exchanging, two owners exchanging. But we know that you really, and Marx knew very well, it is a legal fiction that the labor owns his body. You don't own your body, you live in your body, you inhabit it, you don't own it. But this idea that it owns is very crucial for the new form in which the law of value, according to Marx, starts operating. So he was quite clear that you might have formal freedom, but absolutely informal, but absolutely substantial unfreedom. He had a very interesting, he would look at a very interesting, metaphor, that I am equal in the sphere of the market, but I have brought my own skin to be to receive a hiding, hiding from the hide, the skin, to get a hiding, to be flayed actually, to be flayed, that means your skin is taken out in the abode of production. Once I enter the sphere of production, I am under direct control of the master. I am under direct control of the master. So how do we, instead of looking at freedom and unfreedom as opposites, exactly as Orlando Patterson said, that unfreedom or freedom is not the opposite of slavery. In fact, freedom needed the background of slavery to emerge. Okay, so they coexist. In a sense, or as he used the term, it was birthed by slavery. Freedom is birthed by slavery. There existed no word for freedom, in a sense, excepting only in relation to slavery. Now, just to give you a kind of a metaphor, instead of looking at freedom and unfreedom as distinct, think of them as like this. Okay? That is, you can have unfreedom at the bottom and freedom at top. Rather than freedom and unfreedom being opposite, one mutually excluding the other. But you can create a new concept, which Marx did, by distinguishing between labor and labor power. Labor power is his total invention. It was not there in classical political economy. Classical political economy, Adam Smith, Ricardo, all of them worked with the idea of labor. He used the labor theory of value, but he made the distinction of labor and labor power. So a legal fiction of labor power is created, which he can then sell temporarily, and then go back home and get fed by his wife and things, and come back again with his labor power to sell. But of course, he will come with his labor power, means someone else cannot come. He has to come. No. So that's one thing. Many other people have looked at, so the question can be in a way looked at. So when I am looking at this status, contract, it's not that we are actually, it's not Kaalchakra in a technical sense, because we are not just going circle by circle, we are dialectically moving into some other field. So it is not contract becoming exactly the opposite status. We can see echoes of that 1920s in the or say late 19th century in the gig workers character. But they are echoes. They are in some sense returning certain elements, but they are of a different nature. Now, I feel that the late 19th, after the AI is coming, if it is coming, we are already in the middle of a massive redundant labor force. The question of freedom and unfreedom would not arise. What the hyper oligarchs are saying is that सबको पैसा कुछ दे दो, जैसे 5 किलो अनाज दे दो, कुछ 1500-1000 रुपए दे दो. Only 1% people will have the money. So now we have this period of the so-called neoliberal form has seen the maximum rise of inequality, which has increased during the crisis, during COVID, after 2008, it has increased. What it was before also, it has increased further. Now only perhaps 19 people in the world own more than India's annual budget, annual government spending and all. Many, more than anyway, how to say that? It's just incredible. What we are living through is one of the world's most incredible times. This inequality did not exist in any period of history. Any period of history. A guy will get $1 trillion as a salary, or his income $1 trillion. That's what Elon Musk is trying to get. Anyway, so this massive shift is something which I want. So what will happen? You have this lot of people. They are not free or free. They are just not there. They are only consumers of. In Roman times also, the plebs actually did not do any work. They were free, but the work was done by the various forms of slaves other types of half slaves and all. The plebs, the urban plebs are important only for voting, whatever, during that. So they had to get, and they had gladiators and the circus and what was the thing called? You get circus and bread and circus. So you get free bread and you get free circus. You could be reaching something like that in a very strange way. Redundancy is such a thing. It's not merely an economic thing. It's also that many of these shifts and transformations that we see has occurred due to internal crisis of this. I'm not sure that the AI will actually succeed because despite everything, human organizations, labor, dignity questions, they still remain important. When I gave you this thing, I might have not focused enough on the resistance or because I was going to be looking at the legal form itself, but we should integrate within it the question of internal conflict and internal. Thanks.
Thank you once again, Professor Mohapatra, for your enlightening lecture. Due to paucity of time, we are not able to take.
You want to ask the question?
I will ask later. I think the next session is up. So I extend my gratitude and thanks to Professor Mohapatra and the History Society and the Executive Council for this wonderful arrangement. Next up is a talk by Professor Najam Haider. So, are there any refreshments? Yeah, so you are welcome to have refreshments outside. Thank you.
I would request you all to stay with us.
Sorry, my apologies. Thanks. Sure, this way.
One second, could you all please be seated for a second? One second. Right?
On behalf of the History Society, St. Stephen's College, I extend a heartfelt gratitude to Dr. Prabhu Mohapatra for that excellent lecture. We would like to present you with a token of our appreciation. I request Dr. Sudipto Basu to kindly present the memento to sir. I would also like to take a moment to thank Live History India Digital Foundation. LHI Digital Foundation focuses on supporting and promoting research on India's history. Through its platform, the foundation works with scholars across the world to document and map India's rich past. It also works to revive India's living heritage, its crafts. The foundation collaborates with artisan clusters across India to help revive traditional crafts and create sustainable livelihoods. We are grateful to Dr. Sudipto Basu for chairing the session today. We also thank Harish Kumar Yadav, Registrar of Societies, and Dr. Sabina Kazmi, our staff advisor. We're also thankful to IQAC. A big thank you also to our non-teaching staff for their logistical support. Finally, we are grateful to all of you for joining us today. We hope you had a great time. We have another event happening at 4 p.m., a lecture by Professor Najam Haider titled Working with Pen and Paper, the Story of the Scribes in Mughal India. Hope to see you there. Thank you.
If you all gather around there for a photo, that would be great.